Something you do every single day just became legally dangerous, and most people have absolutely no idea. If you keep a firearm in your vehicle, whether it is in your glove compartment, under your seat, in your center console, or locked in a case in your trunk, the Supreme Court of the United States just issued a ruling that changes the legal ground you are standing on. 6 justices voted one way, 3 voted the other, and that split alone tells you how serious and contested this issue really is. This is not a hypothetical. This is not a warning about something that might happen someday. This is happening right now, today. And if you drive with a gun in your car and you have not heard about this ruling, you are already behind. You are already at risk of making a mistake you cannot take back. We are going to walk through everything. What the court decided, what it means in plain language, how it affects your daily life, what law enforcement can now legally do that they could not do before, and what steps legal experts say every vehicle gun owner must take immediately to protect themselves. Stay with us, because by the time we finish, you are going to understand something that millions of gun owners across this country still do not know, and that gap in knowledge is exactly where legal trouble begins. Let us start with the moment this all became real. Picture a routine traffic stop. It happens every single day, thousands of times across America. A driver is pulled over for a broken taillight. Standard stop. The officer approaches the window. During the conversation, the officer notices something in the vehicle, a firearm, legal, registered, owned by someone with a completely clean record who has never had a single problem with the law in his life. What happens next used to be fairly predictable. Depending on the state, the officer might ask a few questions. The driver explains the situation, everything checks out. The stop ends, and everyone goes home. That predictable sequence just got a lot more complicated, because the Supreme Court ruling that just came down has fundamentally altered what law enforcement officers are legally allowed to do when they discover a firearm in a vehicle during a traffic stop. It has changed what questions they can ask, what searches they can conduct, what they can seize, and under what circumstances a perfectly legal firearm in a perfectly legal vehicle can suddenly become the center of a very serious legal situation. And the worst part is this. Most gun owners who keep firearms in their vehicles have no idea the rules just changed. To understand why this ruling happened, you have to understand a legal tension that has been building for years. Because your car does not get the same Fourth Amendment protection as your home. Not even close. Courts have long recognized what legal scholars call the automobile exception. The basic idea is that because vehicles are mobile, because evidence can be moved or destroyed quickly, law enforcement has broader authority to search vehicles than they do to enter your house. That exception has been part of American law for over a century. But exactly how far it extends has been debated and litigated endlessly, and nowhere has that debate been more heated than in cases involving legally owned firearms discovered inside vehicles. Here is the core tension. The Second Amendment gives you the right to keep and bear arms. The automobile exception gives law enforcement broad authority to search your vehicle. What happens when those two constitutional principles collide? What happens when a legal gun in a legal car meets an officer with broad search authority and serious questions about why that gun is there? That collision is exactly what this Supreme Court case was about, and the answer the court gave is what every vehicle gun owner in America needs to understand today. The case that made it to the Supreme Court involved a lawful gun owner, no criminal record, a valid concealed carry permit issued by his home state. He was driving through a neighboring state when he was pulled over for a minor traffic violation. During the stop, the officer discovered the firearm. Here is where it gets important. The neighboring state had different laws about concealed carry than the driver's home state. His permit was valid where he lived. Whether it was valid where he was driving was a legal question. And in that gray zone between one state's laws and another's, a situation escalated that should never have escalated at all. The officer detained the driver. The firearm was seized. The case went to court. The driver argued his rights had been violated. The state argued law enforcement acted within its legal authority. Lower courts split on the issue, and eventually, the case climbed all the way to the highest court in the land. The Supreme Court took the case because courts across the country were handling these situations differently. In some states, a driver with a firearm had strong legal protections. In other states, law enforcement had much broader authority to act. That inconsistency, that patchwork of conflicting rules across different jurisdictions, created exactly the kind of legal chaos the Supreme Court exists to resolve. So the court resolved it, 6-3. And the resolution is something every American who keeps a gun in their vehicle needs to understand carefully. Here is what the majority held. When a law enforcement officer has reasonable suspicion that a firearm in a vehicle may not be legally possessed in the jurisdiction where the stop is occurring, that officer has constitutional authority to conduct a limited search and to temporarily seize the firearm during the stop for the purpose of verifying its legal status. The key phrase is reasonable suspicion in the jurisdiction where the stop is occurring. In plain English, that means this: the laws of the state where you are currently driving, not the state where you live, not the state where you bought your gun, not the state where your permit was issued, govern what an officer can legally do during a traffic stop. And if there is any gap between what your home state allows and what the state you are driving through requires, that gap creates what the court called a reasonable basis for further inquiry. And further inquiry now includes search and temporary seizure of your firearm. Read that again. Because it is important. If you are driving through a state with different gun laws than your home state, and an officer discovers your firearm, that officer now has Supreme Court-backed authority to search your vehicle and temporarily confiscate your firearm, based on nothing more than the fact that your permit does not clearly comply with the laws of the state you are currently passing through. You do not have to be doing anything wrong. You do not have to have a criminal record. You do not have to have threatened anyone. The simple fact that you are in a state with different gun laws, combined with the presence of a firearm in your vehicle, is now legally sufficient to trigger that authority. The 3 dissenting justices were very clear about why they believed this was wrong. And their arguments matter because the legal challenges to this ruling are going to be built on exactly what those justices wrote. The first dissenting opinion argued that the majority's framework makes your constitutional rights under the Second Amendment weaker every time you cross a state line. That the right to keep and bear arms is a federal constitutional right and cannot be legally diminished simply because you are driving through a state with stricter gun laws. This justice argued that allowing local law to effectively override a federal constitutional protection is inconsistent with the entire framework the country was built on. The second dissenting opinion focused on practical consequences for real people. This justice laid out in specific terms what the majority's ruling actually means on the ground. It means a gun owner driving from one side of the country to the other is legally exposed to searches and seizures at every state line. It means the legal status of your firearm can change the moment you enter a new jurisdiction. It means the burden of navigating an impossibly complex web of state-by-state gun laws falls entirely on the gun owner, and innocent failure to navigate that web perfectly can now result in the seizure of your property. The third dissenting justice argued the ruling will hit hardest on rural Americans, truckers, long-distance travelers, and people who live near state borders and regularly cross them for completely normal everyday reasons. This justice called it a geography tax on constitutional rights. If you live in a city and never leave your home state, your risk is lower. If you regularly cross state lines, your risk just went up significantly. 3 dissenting justices, 3 powerful arguments, and yet 6 justices voted to uphold this new framework. That is the law of the land now, and understanding it is not optional for vehicle gun owners anymore. Now let us get specific about what this means for your daily life. In the weeks since this ruling came down, several law enforcement agencies have already issued new internal guidance to their officers. Officers are being told they now have clearer legal backing to ask detailed questions about a firearm's legal status, to request documentation beyond what was previously required, and in some circumstances, to conduct a search of the vehicle to verify the information provided. This is not speculation about what might happen someday. This is already happening, and it started faster than most people expected because many law enforcement agencies had been watching this case closely and had their updated guidance ready to go the moment the ruling came down. Now let us talk about documentation, because this is the most practically important thing you can take from everything we are covering today. Under the new framework the Supreme Court established, an officer who has reasonable suspicion about the legal status of your firearm can search your vehicle and temporarily seize the weapon. The most effective way to neutralize that reasonable suspicion before it becomes a problem is documentation. Clear, complete, immediately accessible documentation that establishes the legal status of your firearm in the jurisdiction where you are driving. Legal experts who specialize in Second Amendment law are now telling clients there are 5 specific things every vehicle gun owner should have with them at all times. Not locked in a safe at home, not buried in your phone somewhere, in your car, organized, accessible in under 30 seconds. The first is your firearm purchase documentation, a bill of sale, a receipt or transfer paperwork from a licensed dealer. This establishes that the firearm was purchased legally through proper channels and creates an immediate baseline that helps in any legal conversation during a stop. The second is your registration documentation, if your home state requires it. And this matters especially when driving into a state that also requires registration. Having purchase documentation and permit documentation together creates a package that demonstrates a history of responsible, legal ownership. The third is your carry permit or concealed carry license. This seems obvious, but the details matter more than ever right now. Your permit needs to be current. It needs to clearly show your name, your jurisdiction, and its expiration date. If your permit is expired even by a single day, you have a serious problem. If your address on the permit does not match your current address because you moved and never updated it, you potentially have a problem. The fourth is a printed summary of the reciprocity agreements between your home state and any state you are driving through. Reciprocity is the legal arrangement where one state agrees to recognize another state's carry permit. Most states participate in some form of reciprocity, but not all states recognize all other states' permits, and those rules change regularly. Having a printed, dated document showing the current reciprocity status between your state and the states you are traveling through gives you something tangible to present to an officer who questions the legal status of your firearm. The fifth recommendation, which several attorneys have now begun making publicly, is to consider carrying a brief letter from a licensed firearms attorney outlining your legal rights as a gun owner in the relevant jurisdiction. This signals to an officer that you know your rights, you have consulted with counsel, and any improper action taken against you will face a serious legal response. None of this is about being confrontational. Being confrontational with law enforcement during a traffic stop involving a firearm is never a good idea and can escalate a situation in ways that are dangerous for everyone. This is entirely about being prepared, being documented, being the kind of gun owner who can demonstrate quickly and clearly that everything is in order and that there is no legitimate basis for reasonable suspicion. Now let us talk about what happens if a situation escalates anyway. Legal experts are unanimous on this point. If an officer tells you they are going to search your vehicle or temporarily seize your firearm, do not physically resist. Do not argue loudly about constitutional rights at the side of the road. Do not make any sudden movements toward the firearm. And do not attempt to prevent the officer from doing what they say they are going to do. Here is why. You have legal remedies available after the fact that you do not have in the moment. If an officer conducts a search or seizure that ultimately turns out to be unconstitutional under the framework the court established, that can be challenged in court. Your firearm can potentially be returned. Any charges based on an unconstitutional search can potentially be dismissed. What the legal system cannot do is undo the consequences of a roadside confrontation that went wrong. Stay calm. Be polite. State clearly that you do not consent to any search. State clearly that you are invoking your right to remain silent. Then say nothing more until you have spoken with an attorney. That phrase matters. I do not consent to this search. Say it calmly. Say it clearly. Even if the officer proceeds anyway under the authority the Supreme Court just confirmed, your verbal non-consent creates a legal record that your Fourth Amendment rights were not waived. That record matters enormously in any subsequent legal challenge. Now let us talk about interstate travel specifically, because this is where the ruling creates the most complexity and the most risk for the most people. There is a federal statute called the Firearm Owners Protection Act that provides legal protections for interstate travelers transporting firearms. This law was passed specifically to protect gun owners traveling through states with stricter gun laws. Under this law, if you are traveling from one state where it is legal to have a firearm to another state where it is legal, and the firearm is unloaded and locked in a container in your trunk, you have a federal legal protection even in states you are simply passing through. That protection still exists. The Supreme Court ruling did not eliminate it. But pay close attention to the specific requirements. Unloaded, locked, in a container, in your trunk. If your firearm is loaded, you may be outside that federal protection. If it is accessible in your passenger compartment rather than locked in your trunk, you may be outside that protection. If it is in a case that is not actually locked, you may be outside that protection. Legal experts are saying this loudly and clearly right now. If you are traveling across state lines with a firearm, the safest legal configuration is unloaded, in a locked hard case, in your trunk or cargo area. Not under your seat, not in your console, not in your glove box, in a locked case, in the trunk. This puts you squarely within the federal statutory protection and reduces the reasonable suspicion trigger the Supreme Court's new framework creates to essentially zero. Yes, this means the firearm is not immediately accessible for self-defense while driving. That is a real trade-off that each gun owner has to weigh personally. But in the current legal environment, until the full implications of this ruling are worked out by lower courts and addressed by new legislation, this configuration gives you the strongest possible legal protection during interstate travel. Now let us look at what is happening in state legislatures in response to this ruling. Because the Supreme Court's decision is not the end of this story, in many ways it is the beginning of a new and very active chapter. Several states have already begun reviewing and revising their laws related to vehicle transport of firearms, and they are going in opposite directions. In states with strong gun rights traditions and Republican-controlled legislatures, lawmakers are moving to pass legislation that maximizes protection for vehicle gun owners within their jurisdictions. These bills are designed to raise the reasonable suspicion bar as high as possible, so that the new authority the court created is applied as narrowly as possible within their borders. In other states, the opposite movement is happening. Legislatures in states with stricter gun laws are using the ruling as validation for a more active enforcement approach, and their officers are being trained accordingly. The result is what legal scholars are already calling a tale of two Americas when it comes to vehicle firearms law. Your legal risk during a traffic stop depends enormously on which state you happen to be in, and that dependence is only going to increase as state-level legislation continues to develop in the months ahead. This is why knowing the specific laws in every state you drive through is no longer optional. It is a legal survival skill for vehicle gun owners in post-ruling America. Let us now bring this back to you personally with a clear action list, because all of the legal analysis ultimately comes down to what it means for a real person who keeps a firearm in their car and wants to continue doing so legally and safely. Here is what legal experts, Second Amendment advocates, and constitutional law scholars are recommending right now. First, audit your documentation today, not tomorrow, today. Pull out every piece of documentation related to your vehicle firearm and ask yourself whether it is current, complete, and accessible. Is your permit up to date? Does the address on your permit match your current address? Do you have your purchase documentation? Can you put your hands on it in under 30 seconds during a stressful traffic stop? If the answer to any of those questions is no, Fix it today. Second, research the specific laws in every state you regularly drive through, not just your home state. Every state where your car and your firearm are likely to be together. Understand the transport requirements. Understand the reciprocity situation for your specific permit. Understand what constitutes a legal locked container under each state's law. Write it down, print it out, put it in your car. Third, reconfigure how you store your firearm in your vehicle if your current setup does not meet the legal requirements of the states you travel through. Make an informed decision about that trade-off with full knowledge of the current legal landscape. Fourth, identify an attorney in your area who specializes in Second Amendment and firearms law and save their number in your phone right now. You do not have to hire them today, but know exactly who you are going to call if a traffic stop goes wrong. Because the first hour after a firearms-related traffic incident is legally critical. Fifth, stay actively informed as this situation continues to develop. The Supreme Court ruling is not the end of this fight. Lower courts are going to begin applying it to new cases. State legislatures are actively writing new laws. Federal agencies are reviewing their guidance. The legal landscape around vehicle firearms is changing, and it will keep changing for months and years ahead. There are also people online spreading misinformation about this ruling right now, and you should know the truth. Some are claiming the Supreme Court has already allowed states to begin confiscating firearms from vehicle owners. That is false. No confiscation authority was created. Others are claiming the ruling fully settled the issue in favor of gun rights and nothing will change. That is also false. New state regulations are already being drafted to operate within the court's new framework. The truth is in the middle. This is not a catastrophe, and it is not a complete victory. It is a significant legal development that requires serious attention and informed action from every gun owner who keeps a firearm in their vehicle. The Supreme Court of the United States has changed the rules. 6 justices found constitutional backing for expanded law enforcement authority during traffic stops involving firearms. 3 justices disagreed powerfully and specifically. The ruling is real. Its consequences are already unfolding in law enforcement training rooms, state legislative committee hearings, and federal agency policy discussions happening right now across the country. You are a gun owner who keeps a firearm in your vehicle. You have done nothing wrong. You have broken no laws. You are exercising a right the Constitution of the United States explicitly protects. And because you are the kind of person who wants to keep doing that the right way, you stayed with us through all of this. You now understand what happened, what it means, and what you need to do about it. The road ahead for vehicle gun owners in America is more legally complicated than it was just a short time ago. But complicated does not mean impossible to navigate. It means you have to navigate it with more care, more information, and more preparation than before. That is what responsible gun owners do. They adapt. They stay informed. They protect their rights by understanding them fully and exercising them carefully. The ruling is in. The consequences are unfolding. And now you know exactly where you stand.